Good morning, everybody. My name is Marty Mascari. I am with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC. And the ADRC is a project under the Area Agency on Aging, and the Area Agency on Aging of North Central Texas is under the North Central Texas Council of Governments. We're blessed here today, once again, with our partnership with Haiman+Hogue to have them here to talk about special needs planning, important information for families of persons with disabilities. And the first thing we're going to do is let Sheila talk about the next slide and talk about CEUs.
Good morning, everyone. Okay, we do have this is really easy to do if you've never joined us before. To get your CEU credit, you do simply two things. A, you fill out the eval form and the sign-in sheet that Marty is showing here, or the name of them anyway. And then B, you send them to me, Sheila@Haiman+Hogue.com. When you do, then I will turn in and send you within just a day or so your certificate. Now, there is something important that we need to say about this particular one. If you are a nurse, this particular one, you're going to get a social worker CEU for, because our guarantor didn't feel this had enough nursing material in there. So you will have to submit it yourself. Okay, I will send you a social worker one, and you can do that, which people do this all the time, because therapists, if you see that we do not, we offer them for usually nurses, social workers, licensed professional counselors, and assisted living managers. Well, they're good for all of them right now, except for nurses on this particular one. So the nurses can submit it themselves, but it will be a social worker one that I send you. Okay, just so you'll know, this particular one, we had some, she just didn't feel like there was enough nursing information in here. So that's why. Okay.
So you'll get those documents in a follow-up email from me. It will be tomorrow sometime that I get those out. I have a commitment right after the webinar today, but I will get those out to you tomorrow with the three documents and the link, and then you're going to fill out two of those documents and return them directly to Sheila, and her email address is here, and her email address will also be in the follow-up email. But understand, if you're a nurse, that there's no guarantee that your jurisdiction is going to take those, but you can submit those yourself. And we've had people in the past do that and have them accept it, but that could be a matter of who you get on the other end. There's no guarantee of that, but just understand today's is not offering CEUs for nurses. But also, in addition to Sheila's stuff, I'm going to also be sending you a link to a Google survey on our behalf that helps us with our funding sources, that we have goals and objectives that we had to set forth when we applied for our funding, and that helps us monitor those goals and objectives and report back to them. So you'll see, so you'll need to do the two documents for Sheila if you want CEU. We're asking everybody, if we could, fill out the Google survey. And again, that is on behalf of the North Central Texas Area Agency on Aging for our funding. So Sheila, I'll let you introduce Rex, if you would, and we'll get rolling.
First of all, I do want to, and you are going to get a disclosure statement from us to say that everything that you hear today, all of the information that we give you, yes, we do this for a living. Planning is what we do. We are an estate and elder law planning firm. However, this is strictly education today. No, we're not promoting Haiman+Hogue. We're not promoting anything like that. We are promoting education for you and your family. Okay, so make that very clear that that's what we're doing here today. But the founding partner of Haiman+Hogue, Rex Hogue, is here with us today. He is known in estate planning circles as a trust guru, so he knows everything about trust and can so answer any questions that you have about that. because a special needs planning does involve a trust. So just know that going in, there's going to be some questions that you may have, and please hold your questions to the end if you've not been with us before. I will be monitoring the chat and the Q&A, and will write down the person's name from the order that I see the questions come in. And then at the end, we will address all the questions together, because I will tell you this, it just makes it more fluent for everyone. It interrupts the flow if we do the questions in the middle, and it confuses everybody. And I don't mean Rex, I mean the people, you that are watching this. So we don't want to do that. So please hold your questions, or just go ahead and type them in. That's fine, but know that they will be answered at the end.
Real quick, if I could, Peggy
Yes.
Milton asked a question, can we see you? We are in webinar format, and in webinar format on Zoom, the only people that have their cameras on are the presenters, the panelists.
Yes.
For the people attending, you will not have your camera or your microphone. It's automatically muted when you come in, and you're not able to turn that on. And we don't turn those on for Q&A just because of the numbers of people that attend. So I just want to answer that for you, if I could real quick.
Yeah,
so you want to introduce Rex, and we'll get going.
Yes, we are. Rex is been practicing law for 30 years, or roughly 30 years. And he is very, very knowledgeable in this area. So please, without any further ado, Rex Hogue.
Welcome everyone to Special Needs Planning, important information for families of persons with disabilities. I'm going to start with what I refer to as the classes of planning dragons. And they're the same for virtually every presentation we do. But the context today is special needs planning. You have administrative dragons, and that's power of attorney failures, guardianship, and probate. And as disastrous as those can be for a regular person, they're even more so for someone with incapacity or disability issues. Then medical documents, and that is a little green dragon that runs along the ground. And then there are taxes, and it's easy to say, well, there's not necessarily a lot of tax issues with special needs folks, yet there are some important ones, and we're not going to spend time really talking about them, but that's the big, nasty, fire-breathing dragon. And then predator dragons and creditor claims. This is another thing that you think, well, this is not a big deal for special needs people. However, it can be, depending on how capable they are. If they're able to drive and do certain things like that, they could very well create liabilities, and you want to make sure that the planning for them protects them from that. Now, we're going to cover the planning itself today. That's what we're good at. What we're not going to cover are the various types and levels of special needs, because it's a very wide spectrum from, not basically being all but bedridden all the way up to fairly high functioning. We're not going to cover agencies that might help. There are a number of them out there, but we're not going to even talk about what they are. And we're not really going to talk about government programs. We're going to discuss how to keep from being disqualified from government programs, though. Special needs, again, it's a wide spectrum, as I mentioned. The terminology that I'm going to use today is special needs planning. It is also known as supplemental needs, and I'm calling it special needs for a very simple reason. That takes less room on the slide, but our actual documents usually say supplemental needs trust. One objective has to be to not cause an incapacitated person to become ineligible for any program for which they might qualify. And it's very important that the person who does the planning knows how to do that, because a little drafting error can have huge negative consequences, both to the incapacitated person and to their family. It does require very careful planning. And it requires starting in the right place. Now, If you've ever been on an airplane, before you leave the ground, the flight attendant will say, you know, here's a little safety briefing. And when they talk about if the cabin depressurizes, the mask is going to come down, put your own mask on first before you help someone else. When you have a special needs person in the family, I cannot emphasize how important it is that you get your own planning in place first, because you really can't help them if your own plan fails. And I'm going to give some examples of that today. If you have special needs in the family, your good planning choices are more limited. And so I'm going to talk about, Sheila already mentioned, you're talking about a trust. Yes, you can will-based planning. It doesn't work well here. Special needs planning involves all three of the planning dragon classes. And normally, if I use this slide at all, I use it later, but literally special needs, it's like being given a bunch of sticks of dynamite and one of them's lit. And if you don't plan carefully, eventually one of them's going to go boom. And when it blows up, the financial consequences to the family and even the health consequences to the special needs person can be devastating. So our first administrative dragon is dealing with medical issues. There's 6 key medical documents. I'm not really going to take time to go through them, but they are important. It is important that you have these, at least most of these documents, for both the special needs person and for the caretaker. It's very important that caretakers have good planning, because they need a plan. If they can't do it, there needs to be a quick way to get someone else in there to take care of the problem. Then dealing with the financial side of incapacity, powers of attorney, that's where a principal gives an agent a power of attorney. It's an invitation to third parties to let that agent act. If the powers of attorney fail, the question becomes, what is Plan B? There are 2 possible Plan Bs. One is a guardianship. That's the court supervised management of assets for someone who's legally incompetent. Or there's a living trust. It can replace powers of attorney. It provides the necessary substitute signature, which is why we go to court for guardianship. And it avoids guardianship and eventually probate. It can also provide instructions for the care of the incapacitated person. And drafting a trust that says, here's the special needs language, but without including instructions for their care, can leave a substitute caretaker not having any idea what that person really needs. Now, the way we wind up in guardianship, a person owns assets in their own name, or if 2 or more people own assets in their own name, and one becomes incapacitated and other planning fails, we go to, typically it's probate court, for guardianship of the estate, which is difficult, and a guardianship of the person, which is easier. Now, when you're dealing with somebody who has special needs, probably from the time they turn 18, it's important that you get a guardianship of the person in place. Now, if you have a trust, incapacity is still an issue, but the rules change. The trust can replace powers of attorney. The trustee holds legal title to the assets. An agent does not. When you're dealing with third parties, the title of that person or their legal position is huge. If you're dealing with a trustee who actually has legal title to the account, you can't refuse to deal with them. But anybody can refuse to deal with an agent under a power of attorney. That's very important when you're dealing with someone who is incapacitated, is to make sure that you have the legal authority, that an institution can't just decide they're not going to deal with you. They work best when you get all the assets in place, and they work best when you have instructions to take care of that incapacitated person. Now, guardianship is not the problem. The problem is that a person is unable to sign necessary documents to manage or transfer assets. Guardianship solves that problem by having a judge authorize a substitute signature. Guardianship is and frequently the only solution to the problem, but is it the best solution to the problem? And the caretakers, if the caretaker undergoes a guardianship, that is going to be a disaster for that special needs person, because as you're going to see, it can take months before somebody else has the legal authority to act on behalf of that incapacitated person. Guardianship is one of those 12-step programs that nobody really wants to be involved in. The minimum cost is $9,500 to $30,000 or more. The annual cost is $2,500 minimum, but usually more. And it seems like a constant stream of surprises, and it goes on for as long as the ward is alive. So what we're talking about here is the caretaker. I mean, the incapacitated person, disabled special needs person, they're already either we're going through this process with them, or we've avoided it for them. But if the caretaker goes through guardianship, we've got a serious problem. It's disastrous for otherwise good estate, business, and asset protection planning, but it's a complete disaster when the caretaker undergoes a guardianship. It's a disaster for that special needs person. The guardianship leads to a lot of time. It takes months to get it in place, a lot of money. There's costs for at least 2 lawyers, a doctor, and a social study. There's a lot of going to court. It takes multiple hearings. And you may have to have that incapacitated person who we've already avoided court for going to court so the judge can decide who should be appointed the guardian of the ward to be the guardian of now the incapacitated person as well. There's a loss of control and a loss of dignity. It opens the door for creditors and predators that are otherwise shut, and it really complicates planning for special needs people. So you cannot ignore guardianship of the caretaker. So we're going to give you an example. Carl and Myra have 3 children, Peter, Paul, and Mary. They've got about $3 million worth of assets. Now, Myra is terminally ill. She can't manage assets herself. Carl has developed Alzheimer's. Their powers of attorney have failed, but they have another problem. They have created a trust, but only their home is in it. That they don't have the instructions to help in their trust, and Paul is special needs. We're not going to identify exactly the special needs because this, we're trying to get you to understand how this comes into play. Well, Carl and Myra have to have a guardianship of both the person and the estate over Paul if they don't already have one over the estate. Now what is needed is they've got to get assets to provide for Carl and Myra. This goes back to they can't take care of Paul if they themselves are not being cared for. They need to sell the house. It's no longer feasible for them to live there. Guess what? Paul lives at home with them. They're going to need to find another place for him to live. They need funds for Myra to be in a facility. Carl is better off in a facility and he's not resisting, but what's going to happen to Paul? They have to have a plan. He can't live on his own and he's unable to hold a job. Now, I've already mentioned he's going to need another home. They're going to need to get a doctor's report for Carl, hire an attorney. They're going to send notice to the interested parties, and that's going to be the kids. And that could be tricky. Paul may or may not have the capacity to receive that notice, and somebody who has that capacity has to be appointed. If it happens to be Carl and Myra and they can't do it, Houston, we have a problem. The judge appoints an attorney ad litem. We're talking about for Carl. And then he has to do a background check on Peter because Peter's going to be the designated guardian for Carl. He has to undergo an approved training program as a guardian. Now, We learned this under COVID. Courts can get backlogged on the background checks, and sometimes those can take months. In the meantime, they have no access to financial info or assets. Mary has to undergo the same thing to help. Now, I'm going to tell you right up front, we have made this an easy case. Peter and Mary are willing to step in and help, but that's not always the case. But until Carl's accounts are accessed, the kids are going to have to pay to maintain the house. They're going to have to cover bills, including medical bills. They've got to care for the parents. And then Peter's going to have a bond up to 3% of the assets. Just doing the math, that's about $90,000 a year Peter's going to have to come up with. Peter's going to have to pay that until he can be reimbursed. The judge is going to appoint a social worker for a social study, or that's going to be done by the court investigator. And again, the background check backlog might be possible. How is all this going to affect Paul? Well, the answer is, without good planning, it's going to be a lot more difficult. Carl and Myra did not plan well for themselves. They think they have a good plan for Carl, but when their own planning fails, their planning for Paul suffers. Poor planning for themselves makes it worse on everyone, but especially Paul. And remember, that's the person we started out trying to care for. Peter and Mary, in this case, have agreed to step up. They live close, they're in a position to help, and they're willing. They love their brother, but they lack the legal authority to do what is necessary. But what if Peter and Mary were unable or unwilling to help? And by the way, Marty, I apologize. I said willing in the slide presentation you have, and I changed it to unwilling. I'll make sure that you get this one so that you can send that correction now. Now, this is an example of what happens with somebody who is taking care of a special needs person themselves becomes incapacitated. That's all I'm going to say about that. Hopefully this is a good story to remind you. Now we're going to look at what happens on death. Pardon me. When a person dies, everything goes through what I call the estate settlement cost funnel. There are 4 types of expenses that come out. Administrative expenses. You will always have administrative expenses. And this raises 3 administrative issues. Which rules apply? How many different rules apply? And where do you put your family in this process? The next thing you may have to deal with is probate, and then possibly creditors or predators, perhaps tax issues. And if the estate is large enough to file a Form 706 estate tax return, it's going to take a lot longer and it's going to be way more complicated. Now, I just want you to think of what happens to Paul, that incapacitated person, while all this is going on. Well, it's going to be difficult. There are 4 ways that assets pass, and only 4 ways. We read these from left to right. So I want you to imagine for a moment, you've gone to the grocery store, you've got your cart, and they scan every item in your cart and they put it in one of 4 bags. Well, on every asset, the first thing we look for, was it owned jointly with right of survivorship? If so, it passes directly to an individual survivor. If that is the incapacitated person, you just will have made them ineligible for virtually every program that would help them out there. If it doesn't pass by right of survivorship, we ask, does it have a beneficiary designation or a transfer on death designation? I call this planning by the box. The reason is the box, what you put in the box determines what the rules are going to be. If you put an individual's name in the box, it's going to go directly to that individual beneficiary. Once again, if that is the incapacitated person, that can be a disaster. And let me give you an example of how that can happen and you didn't expect it. Let's say somebody has a life insurance policy. They name, perhaps in this case, Carl, let's say, has a life insurance policy. Myra dies, he's named Myra. The default, if he hasn't named backups, is Peter, Paul, and Mary. That money going to Paul becomes a disaster for Paul. It makes him ineligible for all kinds of programs. They never anticipated that. So it's very important that this kind of stuff be mapped out very carefully to protect that special needs person. Now, once you get the assets down to here, these two have an identical set of rules. They're not the same going from top to there, but they're the same when you get there. Now, if it doesn't pass by beneficiary designation or TOD, transfer on death, we ask next, is it owned by a trust? If so, it passes according to the trust terms. By the way, you can lose control over what happens with right of survivorship and beneficiary designations, as well as blowing any tax planning. Now, with the trust, if it isn't owned by the trust, the only thing left, it's owned by an individual, and it goes through probate. We're going to talk about probate a little bit. Then it's controlled by the will or intestate succession. Our legislature has graciously drafted a will for everybody who either doesn't have one or their will is not valid, and it's called intestate succession. Now, that will, if we've used a trust-based plan, after probate, that will pay it to the trust. We call it a pour-over will. And then you can name the trust as the beneficiary in the box. That will keep the disaster from accidentally including that special needs person. But the last default of the box, or you can even name it in the box, is the probate estate. And then it gets down to intestate succession or the will. Now, let's imagine for a moment that we don't have a will. What the legislature says is this goes equally to the kids. If Paul is incapacitated, and we're talking about Carl or Myra or both, Paul just became a beneficiary of that in probate. Bye-bye all government benefits. So we see the same things, but hopefully you see how disastrous this is when you have somebody who's already incapacitated. Now, while all four of these get assets to beneficiaries, they're not equal in the way they do it. So we're now going to look at the administrative rules. You always have to look at case law, banking regulations, the Internal Revenue Code, and Treasury regulations. Now, right of survivorship, beneficiary designations, and TOD have a common set of rules in this big red box. We're going to see them. In each state where there are owners, survivors, beneficiaries, or where assets are located, we could have these rules come into play. But the first thing you should note is there are special bad tax rules under the Internal Revenue Code that apply to these two methods of passing assets. Now, let me tell you why that's particularly disastrous when you have a special needs individual. If Paul, for example, receives assets in this way, they get a power of appointment. He gets to decide who gets the assets. That little feature will make him ineligible for government benefits. But there's other laws that come into play, and you've got to look at these in each state where you have an owner, a beneficiary, all that stuff. And that's the estate or probate code, the property code, the insurance code, or the family code. Now, if it's owned by a trust, we deal with one set of rules. The trust code and the trust itself, the trust code of the state where that trust is based. If it's owned by an individual, we have to deal in each state where there's a real property interest. We're going to have to deal with the probate code, the property code, and go through probate in each of those states. Now, a little bit about probate. Probate technically means to prove up the will. So people sometimes think, well, if I have a will, it'll avoid probate. No, it won't. It guarantees you'll be in probate because you have to go to probate court to prove the will is valid. I prefer the layman's definition. It's the court-supervised transfer of assets for somebody who has died. People always want to know how much does probate cost and how long does it take. That's great, but they're the wrong questions. Nobody can give you an honest, straightforward answer to those questions. The reason is, I'm going to show you on the next slide, but what you should ask, who gets paid first and who controls this process? So under the Texas Estates Code, the very first people paid in probate, up to $15,000 each, are funeral and last illness. And that's each if the court approves. And when you see phrases that say, if the court approves, you should understand the way the court approves things is lawyers go to court and argue it. So that's not the cheap way to get things done. Then if there's a family allowance up to 1 year for qualifying family members. Now, I'm going to keep going back to Paul. Paul would be a qualifying family member here. But that family allowance needs to be used carefully so as to not make him ineligible for programs. Then comes the cost of administration, attorney's fees, court costs, executor fees, preserving safekeeping, managing the estate, and unpaid guardianship fees. Then secured claims and tax liens, unpaid child support and interest, taxes, penalties, and interest. Yes, I hear you all cheering. That is the IRS. They're number 6 on the list in Texas. Isn't that great? Somebody finally beats the IRS. Then the cost of confinement if that person was in jail or prison. Then repayment of medical assistance, for example, Medicaid. Then any other claims. If, for example, let's imagine that somebody has a rental home. Well, they may, in going through probate, discover that until you get through that probate, that person may not have to pay rent. They can wait until a designated person takes over for the person who died. After all, if I'm a renter, I agreed to pay John Doe. John Doe died. I'll write a check to the estate of John Doe, but until somebody's appointed and gets authority, I don't have to write them a check. I can live there for free. That can be troublesome in the best of conditions, but it's really unhelpful when you have an incapacitated person out there. Who isn't on the list? Well, it's the family. The family and loved ones are last on the list in probate. Now, who controls this process? I wish I could tell you that it's the lawyers and the courts, but we don't. It's all these people in places 1 through 9 who might make a claim. We don't know how many people will make a claim. We don't know how much their claim will be for. We don't know how long it will take to resolve that claim. And we don't know what it will cost to resolve that claim. That's why if somebody tells you probate's going to cost X and it's going to take this amount of time, they cannot possibly know that. There are too many unknowns here. I've had people say, oh, mom and dad died, they didn't know any debts, there's no creditors out there, and they go open a probate and all kinds of people make claims they didn't have any idea existed. Sometimes they don't know about claims that are out there, and sometimes people make claims that aren't necessarily legitimate. Now, just remember this, when they have a special needs person, taking care of that special needs person If there's not another way to do it except through probate, it's going to be complicated, difficult, and take a lot of extra time. Now, this is my normal definition of probate, but it is even worse when we're dealing with a special needs person. Probate is a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. In my experience, none of those people are on the list of people they're trying to protect. Now we're going to switch cases. Merlene died, and she had 3 children, Harry, Don, and Norma. She died on a Sunday. 8 days later, Norma came to see us. Norma wants to probate Mom's will. Now, it turns out that only 20% of the assets passed through her will. She has a home here and a property in Wisconsin. 80% of the assets passed by right of survivorship, transfer on death, pay on death, or beneficiary designation, and those are all financial type assets. Both sons are in second marriages. She didn't like either of her new daughters-in-law. So what happens? Well, I'm going to take these one at a time, and yes, we have a special needs person in here. But remember, I'm also trying to give you easy cases so you see how difficult it is in the easy cases. Norma lives here. She's in her first marriage. She has kids, no issues. The hot Texas real estate market explains her hurry. She actually brought a 23-page package back to us the day after we gave it to her, and it was filled out. She can't sell the Texas real estate until after Texas probate, and she can't sell the Wisconsin real estate until after the Texas probate and then the Wisconsin probate. Her 1/3, 80% goes outright within a month, but offers her no protection. Harry, he's in a second marriage. He's got kids prior to the marriage. In fact, they're minor children. He died 10 days after his mom, the day after Norma came to see us. Of his 80%, the financial assets, well, right of survivorship vests in both Texas and Illinois in 5 days. Now, if he had a special needs child, Merlene's planning would have made that child ineligible for government benefits because of her own failure to plan, because she thought, well, that's my son's problem. He's got a special needs child. Guess what? Her lack of planning turns into a disaster for the grandchild. Beneficiary designations vest immediately. Now, it turns out that he had a simple will with his new wife. 80%, it's all going to her. If he didn't have a will, some would go to his kids. Now, his 1/3, 20% of it comes from the will. The will required that he survive by 30 days. He didn't. Therefore, that part will go down to his kids. Now, if he does not have a will and he has a special needs child, he just made that child ineligible for government benefits, as if Merlene hadn't already done enough damage for that. Furthermore, 80% of what was going to him is going to go to the new wife, who owes no obligation to that prior marriage child. And when the kids do get it, they're going to undergo a guardianship. Merlene loses 100% control of this. Now, I've been asking you what happens if Harry has a special needs child. Now I'm going to give you the easy part. He doesn't. Don, he lives in Wisconsin. He's also in a second marriage. Kids prior to the marriage, his are adults. But he has one severely handicapped adult child, and they've done a lot of planning for him. Of his 1/3, half of it comes from right of survivorship, TOD, and POD. Now, the bank tells him that money's paid when he told him on Monday, the same day that Norma came to see us. So he said, I'll come in tomorrow to open a new account. But before he leaves the house, he is served with divorce papers and he spends the day getting a lawyer. What happens to him the next day? Well, he gets the call that his brother Harry died. So mom dies on Sunday. The following Tuesday, 9 days later, he finds out he's going through a divorce. Wednesday, his brother Harry dies, and that explains why he did what he did next. Instead of taking time to go to the bank and set up a new account, he put the inheritance in a joint account with the wife who's suing him for a divorce and goes to his brother's funeral. Now, under Wisconsin family law, that means his wife gets a third of it. Now, that is how Merlene loses control of 1/6 of what was going to him. But think about it. That's 1/3 or 1/6 less that he's going to have to take care of his adult child who is special needs. So Merlene's failure to plan properly affects her grandchild. And the special needs adult child, they're dealing with it, but unfortunately, mom's planning had a negative effect that Don couldn't have planned for. But we're going to assume that Don has actually planned really well for that child. But his mother's failure to plan properly has a negative effect on that child. Now, what could a trust have done? Well, first, all the assets would have passed by the trust terms that's more favorable to everyone involved. It avoids probate in both Texas and Wisconsin. Norma's would have gone all to her. It would have been protected from existing creditors, future lawsuits, and divorce. Harry's would have gone all to his children. It would have avoided guardianship. It could have provided for their college education instead of them getting it when they turn 18. It could have protected them from their existing creditors, future lawsuit creditors, and divorce. Don's would have gone all to him. It would have then been filtered into the planning he had set up for his special needs child. It would protect him from his existing creditors, future lawsuits, and divorce. His wife wouldn't have been entitled to any of it. And his special needs child would have been cared for without any loss of assets going to the ex-spouse who his mom didn't like anyway. Now, trust, while the trust maker is alive, it can avoid guardianship for assets in the trust. It can provide instructions for their care in case of incapacity. It can give you a chance to see how the successor trustee does managing assets, easy to change and update. Can have special needs planning for the future. They work best if the assets are fully aligned. Now, I failed to put this in the slide. I apologize, but we had a client come in one time. They've got an adult child who's special needs. This adult child worked as a custodian in a hospital, and it turns out that he had a pretty nice retirement. Well, we were able to do a trust for that child whose assets are going to keep him from being special needs as long as he has those assets. But we were able to get the parent stuff set up so that if he ever runs out of assets, their assets can step in. So sometimes those people do well enough that they need their own planning. Well, it turned out to be a very good thing that we did that planning, because the parents who were providing for his care, one died, the other became incapacitated. Fortunately, we had planned for that. Now, asset alignment, we mean making sure that the assets are aligned with the trust so that each asset is controlled by the trust. Managing assets outside the trust may require court oversight. It certainly could lead to it. Again, think of how that would affect a special needs beneficiary. Lack of asset alignment makes administration more complicated. Way more complicated if you have a special needs person in the family. The trustee has to know and apply multiple sets of conflicting, potentially anyway, conflicting rules. And they may conflict and make that special needs person ineligible. To avoid that, it's going to take a lot more time, effort, and money in planning because it wasn't done right the first time. The trustee is better off getting those assets aligned properly so they have one set of rules to avoid guardianship and probate. Now, the application of this to special needs, take care of yourself first. Your failure to take care of yourself properly will have a negative impact on a special needs beneficiary anywhere among your descendants. Carefully plan for the special needs individual. Make sure that the plan addresses their needs and doesn't make them ineligible for things. Coordinate that planning to avoid assets going to unintended people, especially if that unintended person happens to be the incapacitated person who you just made ineligible for government benefits. Keep the courts out of it as much as possible. Regrettably, when you have a special needs person, you are going to have at least some court involvement, but you can minimize it with good planning. Your planning is going to take more time, but it is time well spent. One of the biggest problems that special needs families have, they are so busy taking care of, little Johnny or Susie, that they don't take time to plan. And I understand it can be very difficult, but they need to do it. It's going to cost more to do it right, but the cost is small compared to the cost of not doing it right. If you've got a child, for example, who the government is caring for under a program, then it may be costing several $1,000s a month to care for that child. Your failure to plan makes them ineligible. They may be ineligible for years, and you might never get those benefits back, but at the very least, you could lose them for a long time. So again, take care of yourself first. Now, tax dragons, I'm not going to say a lot about this, but you may remember those days when the IRS went through the new friendlier IRS stage. I'm just going to show you a picture. We had a case against him back then. He's using a poly Teflon blade for a smoother, less irritating cat. Here's what you need to know about the IRS. They are only in it for the money. The IRS declares war on your family after death. They're going to bring their ship into your harbor. We like to call this ship the IRS Assure Money. And when you look at this ship, what's missing? Yeah, I know you're thinking it's the sails. No, it's the pirate flag. Because what the IRS is there to do is haul your money off to the U.S. Treasury. Your family has two choices. They can raise a white flag and write the IRS a check for whatever the IRS says, or they can fight. You have to give them the tools to fight. Here in the U.S., we have two tax systems. One for those who are uninformed or unwilling to act on what they know, or one for those who are either educated or seek wise counsel and who act on that education or advice. Guess who pays the least in taxes? It's not the uninformed or unwilling. It's those who act. Which category are you in? Now, I want you to understand your tax failure, your failure to do good tax planning can have a very negative impact on that special needs person. Namely, that you might be paying the government money that could otherwise go to your beneficiary, and not done correctly, it could also make them ineligible for benefits. So I've not spent a lot of time on this, but just be aware you can't ignore tax issues when you have a special needs individual. Hire professionals. and I mean somebody who deals with this regularly, not somebody who, yeah, I saw a movie one time about a special needs person. I know what to do because of what they did in the movie. Probably not. Know the tax rules and how they affect special needs. Apply the tax rules. Act on those rules. Use multiple tax strategies where appropriate. Now we're moving on to our third dragon class, and that's the asset protection dragon, protecting and preserving assets from unnecessary loss. Now, before I go to the next point, unnecessary loss means that you have lost benefits for a special needs individual. You have to think of this as asset protection planning. And yes, you want to avoid being the victim of the lawsuit lottery. If you are, it victimizes your special needs person as well. Now, if you have a special needs person in the family, and it could be a child or grandchild, the biggest risk to your estate plan is the failure of the special needs planning. The second biggest risk is your child's spouse's divorce lawyer. Then dealing with beneficiary debts, extraordinary bills, especially medical bills, and you're going to have those when you have special needs people in the family. Creditor threats, future lawsuits. Does a beneficiary have a high-risk job? Or do you have a special needs person who might be capable of driving, maybe up to 40 miles an hour, but they're dangerous on the freeway? I've had people have that kind of situation, and they have to be careful where they let them drive. They can get overwhelmed, and so they present a little bit bigger risk on the road than the average person. Not all of them, but some of them do. What state does a beneficiary live in? Each state has its own rules about dealing with special needs. We're not going to go through all 50 of them, I'll just tell you that. But you need to know what the rules are, where they are. Then how would the loss of those inherited assets affect the beneficiaries? And remember, one of those beneficiaries is special needs. Well, that's why you want to make sure that you know where those dragons are coming from and be prepared to meet them. And when a beneficiary receives assets, they can get it outright. That is a total disaster for the special needs child. Offers no protection and will make them ineligible for government benefits. It can be in a convenience trust. This is another disaster for the special needs beneficiary. Convenience trust is not going to work for them. It'll make them ineligible for programs. Or you can do a heritage trust or a special needs trust. Now, rather than put both of them up there, I focused on the heritage trust because they have a lot of similarities. But they are different, but in the ways I'm going to talk about, they're identical. That can protect a beneficiary from creditors and lawsuit creditors, bad marriage, first death and benefit, but especially loss of government benefits. That's something you definitely need to preserve for that special needs individual. Now, Carrie was a young lady. She inherited all of her parents' estate. A few months after she got that inheritance, she was very responsible. She was involved in a car accident. Somebody tried to go around her at an intersection, clipped her bumper, caused her to veer off, and she T-boned a van load of daycare kids. He killed a driver and 2 kids. Unfortunately, Carrie was found 10% liable. The guy who hit her was found 90% liable. Now, $9.8 million judgment. I'll just tell you, she inherited $3 million. How much did that lawsuit cost her? If you said $980,000, that's a great guess, but unfortunately you're wrong. We have something called joint and several liability here in the United States. That means if you're partially responsible for something that causes a lawsuit, you could pay for the whole thing. It depends on what state you're in. This accident took place in Colorado. Under Colorado's law, if you are 10% liable, you can pay for the whole thing, carry lost, or entire inheritance. If you live in California and you heard about the accident, you could pay for all of it. Yes, I hope I'm kidding, though my California colleagues tell me it may not be that far from right. Texas, you have to be at least 50% liable before you have to pay for the whole thing. So you can't ignore what states not only people live in, but what states they travel in. And you need to plan better than Carrie's parents planned. Compare her story to the story of Ted. Ted got a little bit too much elbow exercise one night, and he failed to negotiate the bridge over the Chappaquiddick River. Mary Jo Kopechne died. The Kopechne family tried to sue Ted Kennedy for millions. Unfortunately, the only thing they could get was his car insurance. Now, we all know that Ted Kennedy inherited millions of dollars. How come Carrie lost all of hers and Ted didn't lose any of his? Well, because of the kind of planning that was done for the two families. Carrie's parents did a convenience trust. Ted Kennedy's parents did what we call a heritage trust. Now, there are 3 questions you ask with predator dragons. What are your risk factors? You really need to know what those are. Those can be identifiable. They're outside the scope today, but we can help you figure that out. We've got material we're even willing to send that will show you that. Then, what assets do you own that are actually at risk? I have people come in sometimes and they say, wow, I'm so worried I could be sued. And we look and they don't have a single asset that could be taken away from them in a lawsuit. You need to know what those are. And then you need to know, what if you did lose those assets? How would it affect you? And if you've got a special needs beneficiary, how would it affect them? So again, that's the flying dragon that some people think just comes out of nowhere. That's because they don't know how to look for them. Now, when you've got a special needs individual, I mentioned a while ago, a heritage trust and special needs trust have a lot in common. The special needs person cannot serve as a trustee. If they are a trustee on their own share, they are ineligible for every program that I know of. Language has to be carefully drafted to take care of a particular special needs person. Now look, there's a lot of people out there who can draft the basics of a special needs trust, but there's a big difference in the needs for a kid who can, have a job, and I've got one of these. The son works at a grocery store. He can't drive, but he can work at a grocery store. They love him. He's a good worker. He's pleasant. And he loves to go to baseball games. He actually pays for season tickets to go see Ranger games. Well, he doesn't drive. He doesn't have necessarily the same high risk that somebody who's higher functioning might have. But we drafted language to carefully care for that and make sure that he gets to keep going and doing those things that he loves to do. You need to look for planning gaps before you do your planning. You need to look for planning gaps in your own planning and fill them. Cover those planning gaps. Make sure that you're covered so that you don't disqualify beneficiaries. Don't try to do this without qualified professionals. Somebody needs to know something about drafting documents for somebody who's, actually incapacitated before they're truly going to be able to help you. Now, can you do this cheap? Sure. you can save money by getting a book on how to take out your own appendix and using a sharp knife, but that doesn't really help in the long run. What you save on fees can cost your loved ones dearly in benefits. And if you're trying to take care of a special needs person, you especially need to be aware that that is the wrong person to try to go cheap on. There are two basic methods: lifetime and after death planning. Now, up to now, we've mostly focused on after death, but you can set up a special needs trust now while you are alive for a special needs beneficiary. Others can contribute if you set it up correctly. So if you've got a special needs child, perhaps the grandparents will be willing to contribute, maybe aunts and uncles, sometimes even siblings. You need to determine eligibility requirements of any agencies you might be working with. You need to determine the requirements regarding the financial issues. So, for example, you might be dealing with one that says, well, we're only going to take people who need to live in a group home. I mentioned the guy who works at a grocery store. Right now, he lives with his parents, and he can keep doing that. But at some point, he will have to go live in a group home. You need to determine the financial eligibility and what exactly is going to be required. So there's a lot of things you have to look at. Then you need to seek outside sources, especially of funding. If there's government funding available, by all means, you need to take advantage of it. Now, this is a typical plan for a married couple with a special needs. And I'm just telling you, if you're a married couple and you have a special needs, you need to do an AB plan. Doing an A plan only is not truly a viable option. The special needs beneficiary can benefit from that B share, but it has to be drafted carefully to do that. Then two things happen. One is we've got non-capacitated beneficiary. We can make the special needs beneficiary as a lifetime beneficiary of that. And let me give you an example. Let's go back to Peter, Paul, and Mary. Carl and Myra could set it up so that upon Peter's death, Paul becomes a lifetime beneficiary as long as he's alive. And after Paul dies, then it would go back to Peter's kids. Now, Peter doesn't have to do that in his own planning, but from Carl and Myra's standpoint, they may want to do that to make sure that Paul is taken care of. And that would apply only to the part that Paul might inherit. You need to consider the real needs. Folks, it has been said that there is nothing more unequal than the equal treatment of unequals. Special needs beneficiaries are not equal to everyone else. They may need more money. They are definitely going to need more careful planning, or at least normally they will. You're going to have to consider things for them you don't really have to consider for healthy, normal beneficiaries. But this is the plan that you're looking at when you're talking about doing a plan that kicks in after you've died with whatever assets you have remaining. And if you have a special needs child, you need to do this kind of planning. But you can also do a standalone special needs trust. It's created while you're alive. It can be funded by gifts. That can be lifetime gifts from the parents, i.e. you, if it's your child, lifetime gifts from others. And you might be surprised, there's people out there who have a heart for this, and they're willing to donate to others. And I'm not telling you that there's a gazillion people out there, but don't overlook the possibility that maybe there's a person in a church that they have a heart for that, and they'll contribute to special needs situations. Then there can be testamentary gifts. That means gifts that are made when a person dies. Again, remember, the beneficiary cannot be the trustee. and you have to draft carefully to avoid losing government benefits. You also have to plan carefully for income generated. So let's just say that you have a special needs trust. You know, Carl and Myra set one up for Paul, and what goes in there is the ExxonMobil stock, which happens to be generating a lot of income at the moment. What happens to that income? Is it subject to Paul? Is it part of his income? If so, that's going to make him ineligible for government benefits. So you've got to plan that kind of stuff carefully. Maybe they have rental properties and they think, well, that's going to supply income from now on. You've got to do that very carefully. It's also important that you not give that special needs person a power of appointment. In other words, on their death, they don't get to say where it goes. You have to say that. And typically, it's going to go to non-incapacitated beneficiaries at that point. Take care of yourself first, then your special needs beneficiary, and then the others. Now, special needs trust and heritage trust for non-special needs, you're going to want bloodline protection. Make sure that it stays within the family bloodline. For that special needs beneficiary, we do a lot of Rockefeller type trusts, or at least partial Rockefeller trust, where people only get the income out. Well, you can't use a Rockefeller trust as to that special needs beneficiary without making them ineligible. But you can determine what is going to happen to that income. You need to keep assets out of the beneficiary's taxable estate. I mean, the special needs beneficiary. Because if anything winds up in their estate, by the way, the government can go back and collect from it for assets that they've put up to take care of that person. You can allow the special needs to be a lifetime beneficiary of the shares of others. Like the example I gave where Carl and Myra might do that for Peter and Mary, to say, hey, if they predecease Paul, their share will take care of Paul while Paul's alive, then go down to their kids. You need to identify personal risk and plan accordingly. Big difference between a high functioning special needs person who drives, has a job, but maybe they just can't manage money, whatever their situation is, versus the one who isn't physically able to drive, but is otherwise healthy enough to have a job, versus the one who's in a wheelchair and has very severe disabilities. Create structures that are difficult to get through. Get others involved. Plan out when you can't take care of that special needs person, what's your backup plan? Partition assets off so that the assets for that special needs person aren't subject to liabilities from other assets. And then you've got to manage that plan like a business. Now, how do you plan? We always analyze the family situation, the financial situation, determine the goals and objectives. We analyze the specific tools. We consider your family situation, and then we figure out what tools are going to meet your goals and objectives. You need to consider what you're trying to protect, who you're trying to protect, from whom are you trying to protect it, and what tools might work in your case. Again, no two cases are alike. They're all different. Now, before planning, you may think, well, I've got money here to take care of my special needs person. But it's all at risk. Dragons are going to come. If you don't do good planning, eventually one's going to come along and take the money that special needs person needs. When you do good planning, you start off with the money, but we build a castle. we put you behind the castle. Guess what, folks? The dragons are still going to come. However, now you have a knight to come out and fight off the dragons while you're protected behind the castle. At this point, I'm willing to stop and we'll take any questions.
Well, good, because there are several. Okay, I'm going to go in the order that I got them. Okay, let's see. The first one is from Melissa. Do you have to submit the guardianship application in the same county as the person lives?
I believe the answer to that is yes. We have an estate administration department in our office who could actually answer that. If you would send us that question via email, we'll be happy to get the answer to that and send it to you.
Okay. The next
I can also submit it to Marty so anybody else could get it too.
Yeah.
Okay, the next question is from Michael. I've heard of life insurance policies called second to die, where the beneficiary receives the benefit upon the death of the policy owner. Is that something that would be good to put into place for the benefit of a special needs adult child, even perhaps through a sibling?
It certainly can be. Second to die life insurance. What happens basically, it's a joint policy. So when the second of those two die, then the policy pays, as long as the payee in that case is a trust that is a qualifying trust for special needs. That can be a great tool. I love life insurance as a solution. It provides a great source of cash, and with careful planning, we can pass it tax-free. So the short answer is yes, that can work.
Okay. The third question is, okay, what happens when I retire? Will my special needs adult child get some of my retirement money? What can I do about this?
Yes, as a matter of fact, you can create what is called a qualified retirement plan trust, and pass it to that incapacitated individual. This is really the only practical way to do it for special needs because, believe it or not, the IRS does not charge any income tax nor any forced distributions as long as that incapacitated person is alive. And once they've passed, the next set of beneficiaries has 10 years that they can let it grow tax-free. So yes, they can get some of your retirement. It does require some very special planning, but the retirement plan trust is almost perfect for an incapacitated individual.
The next one, it's Jackie that was actually trying to help Helen, and she said, yes, they will get money. Look into the pickle amendment. Do you know what that is?
I'm sorry, I'm not sure I got all of that question, Sheila.
It says, yes, they can get money. Look into the pickle amendment.
The which amendment?
Pickle.
Sorry.
As in dill pickle, pickle.
Okay. I guess I'm not familiar with it. We do know how to do that in a retirement plan trust.
Okay. The next question, back to Helen. How can families with low income plan for their special needs children if attorney fees are astronomical? Any agencies willing to help families?
That's a very good question. I do not honestly know the answer. There are several possibilities. One is you might be surprised at family and friends who might be willing to help on that. perhaps your church or religious organization might be willing to help some on that. You might even find attorneys out there who will, even though these are way more complicated than the regular case, that might be willing to work with you on that. I would not give up merely because the fees are high. You might be able to work out some kind of a payment plan. I wouldn't give up just because it looks difficult.
Okay, now that is all that I see. Who else has a question? Now is a good time.
We're trying to, I just want to make a point, we're trying to actually put together a training on legal aid for in Texas, what's available. So that may be, I'm not sure if the Texas State Legal Center does that, but that may be, I know they do the transfer on death deeds, so I don't know how much they do, but there's, but those obviously, most of those case people have income guidelines where you have to meet their low, extremely low income guidelines.
And you do need to be very
transfer on
careful.
death is not going to work in this case, though, is it, Rex?
I'm sorry, ask that again.
That transfer on death deed, that wouldn't work in this case, would it?
Depends on who you're transferring it to. If it's transferred to a trust that's designed for special needs, it can work. But if you transfer a home to an incapacitated, $500,000 home, as far as the government's concerned, they just got $500,000 or something they could convert to that and pay for their own care for a long time.
Yep.
So you got to be careful. It can be done. You just got to do it the right way.
Yeah, and I was just using that as an example of what I know they do, but I don't know if they handle the rest of it. Is what I was trying to point out there in regards to for low income, families.
Okay.
Okay. Here is Austin. That Rex, he can answer that question that came up earlier.
Let
me see. Okay, let me find it.
Good morning, Austin.
Morning.
Do you have to submit the guardianship application in the same county as the person lives?
Yes, the court will only have jurisdiction over the case if the person is physically located in that county.
Does that help, Melissa?
Great.
Thank you, Austin.
Yeah, thanks, Austin.
Melissa said thank you and yes. Perfect.
Okay.
That's it. Thank you.
Perfect. Let me know if there's anything else I can do to help.
Okay, here's another one from Janice. My special needs son is 35 years old. My brother from New Jersey passed from COVID in January of 2022. I'm sorry, Janice, that's terrible. I inherited his home in New Jersey and bank accounts. I have two other non-special needs adult children. And I'm sure she's asking, what should she do?
The first thing, talk to someone like us, get a plan done for yourself that takes care of you. You're looking at doing definitely living trust-based planning, and then make sure that that trust has special needs provisions for the adult special needs child. And then carefully consider how you're going to give it to the others and what other kinds of things you might do. But yeah, exactly what we're talking about applies. You need to start by doing planning for you and for the special needs child. Typically people do that more or less at the same time.
Okay, and then an anonymous question. If someone is kicked off governmental benefits, how long will they have to stay off, and how difficult is it to get back on?
They, at the very least, they're going to have to stay off for as long as they lack the resources. I mean, for as long as they have the resources or the government perceives they have the resources to get back on. And then once they no longer have those resources, you can apply, but that doesn't mean that they're going to get those benefits instantly. And that's one of the reasons that I've tried to focus on don't make them ineligible, because you make them ineligible. Well, let's just say you made them ineligible for a year. It might take 2 or 3 years to get them requalified after that year passes. So making them ineligible is a disaster you need to try to avoid if at all possible.
Can I ask a question just to kind of make a point? Now, once they've inherited money, the special needs person, then they're going to have to spend that down, because they can't, after the fact, put that in a trust or gift it to somebody in order to make themselves eligible. They have to spend all of it down. And then once they become eligible, then they can apply, but then they've got to go through the waiting process after that to get the benefits. Is that not correct?
That is exactly correct, Marty.
So
remind me the next time I do that. That's a great way of explaining what happens.
yeah, so if you have $500,000 that ends up let's just say you have $200,000 that goes into your special needs, goes to your special needs child, and the cost of care that they're getting from the government is $4,000, and they lose that, then they're going to have to spend down that $200,000 at $4,000 a month until they, number one, qualify again or spend it all the way down. But they can't even apply till they've spent it down for the benefits. So once it's spent down, after that, they can apply for the benefits, but then they have to go through the waiting process to get them, and they're out of money. And so who takes care of them in that meantime? So that's a very, very important reason why this is so important.
Yes.
And
We actually had a case like that. Person got money, the parents were taking care of them. It made them ineligible, and the parents realized by the time the spend down is done, they're likely to be dead. And then who's going to apply on behalf of this child? You know, one thing I forgot to mention, sometimes the siblings, they've had it up to over their head with this special needs person. That person has gotten the attention of the family for all those years, and they're done. They don't want to help. They don't always live close. I've even had people tell me, yeah, we had, you know, the one child that we could likely have counted on for help moved halfway across the country. Maybe because he didn't want to have to do this, and being halfway across the country made it where he didn't have to. So I presented easy cases here where the kids were close and ready and willing and able to help, but that is not the case by any stretch of the imagination in every case.
there's one more. Melissa has another. This is a good question. I'd like to hear the answer to this myself, Melissa. If a guardianship was already in place, could the special needs child just reject the inheritance?
That probably depends on how exactly it is passed to them. You may be able to do a qualified disclaimer that has to be done within 9 months of the time of the person's death. But the other thing you have to be aware of is if a government agency finds out, oh, you just turned down $500,000 that went to somebody else and it could have paid, okay, you just became ineligible for the next $500,000 worth of benefits, and when that time runs out, then you can apply again.
So it
So
would
you have to.
It would be treated just like the disposition of assets. If you were to gift assets or something, it would be treated in that same way. Is that correct?
That's correct.
The whole point that Rex and we're trying to get across to you is that this is very difficult at best. and you want to do the right thing for your special needs individual. And when you know, if you are my age or older, then you have to look at who's going to take over for you. And it may not be your children, because they may not want to have anything to do with this, even if you've done the right planning. This is just this is why this was so important to do today, because this, the special needs person could be because of special needs at birth. It could be because of an accident. It could be because of extreme disability due to drug use. It could be a lot of reasons. It doesn't matter why. The problem is he's right. The SSDI, if you have to reapply for that, I know this by personal experience. If you have to reapply for this, well, number one, you better get a good lawyer, but secondly, it is not easy to do this. Well, and so whereas if you had done the right planning to start with, then
yeah, and if they're disabled to the point where they need to be in a special living environment or anything like that, this can be truly catastrophic for the person that's disabled, because what you do is you make them ineligible, they spend it down, and then they have nothing until they can get back on the get on the waiting list and get to the top of the waiting list, and that can be just catastrophic for them.
Yes, and another good point on that is you pay an attorney to go do this planning. You do something that causes them to become ineligible. Let's just use the example of it makes them ineligible for 4 years, and then they have to apply again. And you're going to pay the attorney to go redo. And, fortunately, fees never go up over a 4-year period, right? Of course they go up. So it's going to be more expensive to go do what you already did once because you didn't do it right. And that's why I tell people, yes, you might be able to save some money, but if in the process of saving that money, you make somebody ineligible, that's way more expensive than getting it done right to begin with.
All right, there's 2 more, but I'm not certain how to pronounce this, Rex. Could you briefly explain 2 words, TE, and then the other word is RETIR?
Career? Yeah. I'm sorry, I don't know what that means. It's something, if somebody could spell it out for us, we could try to look that up and get back to them.
I don't.
The person that asked how long it takes to get on the government benefits once they get off, and that very much depends on what government benefits you're talking about. It differs on what the needs are of the person who's disabled.
Yeah, we had one where a person was deemed to be eligible for a program, but there was about a 30-month waiting period.
Mm-hmm.
So that can come up too.
I have no idea. I don't see that, Rex, on Google. I don't know what it is. Okay, but then there's one more question, and it is involving what we were just talking about. Hi, I have a medically by cancer disabled person. I had applied for SSI for him. He was qualified by the time of payment. However, then he received his tax refund, and the Social Security denied his case because that exceeded his income limit. My point is, can income tax refund or child credit go against a disabled person?
Well, for sure, a tax refund can. Any resources that go straight to that beneficiary you run the risk of it making them ineligible.
Okay.
I'm going to answer Peggy's question if I could. And
Sure.
Peggy, you have to be, this is a question we have to be careful to answer because, you know, we can't be selling services here, but you're more than welcome. You have Haiman+Hogue's information here. You can contact any attorney, but for someone to contact you, that would be inappropriate for us to out of here, but you can contact them or you can contact anybody else that you'd like in regards to what your needs are.
Okay, Yolanda is I think it was a spell check problem. It was a retirement trust that she was talking about. I was unaware that my adult special needs child would begin receiving part of a parent's retirement money. And so that's why she's saying, does she need that to protect that for her son?
Wow. So if I'm understanding the question, her parents died and they named special needs grandchild as a beneficiary. Unfortunately, they have just created a big mess for him because unless they set up the planning properly for him, by doing that, they may have made him ineligible.
I think I read the question a little bit differently, and I may be wrong, and you can tell me if I'm wrong on the chat. But I think what she's asking is, does her disabled child automatically get part of her retirement? And I think maybe what she's referring to is Social Security, because the disabled child is going to be eligible for Social Security disability, but that's not going to affect the amount she gets for her retirement. Is that correct?
Yeah, it shouldn't affect what she gets.
In other words, what the child gets does not come out of her Social Security once she retires. The child has its own benefits.
Oh yeah, one doesn't. Yeah, that's not the same thing.
I think that's what I understood that the question was, but I'm not sure. And she can clarify it if that's.
Yeah, because I'm not sure any of us understand what she's.
Yeah. But no, if your son is getting Social Security or Social Security disability because they're disabled, that's not going to affect how much Social Security income you get at retirement.
Correct.
Two different pots of money. And if you got, I've got another commitment. So if we could we go to the CEUs if we could? And I apologize. I got tight scheduled this morning, and I know it's 38 after the hour. But if we go, that's great. If you could go over that one more time, Sheila.
Sure. Okay. Two things you need to do. You're going to receive, when Marty sends you the confirmation email after this, you'll get 3 forms. An eval form, a sign-in sheet, and a disclosure statement. The disclosure statement just goes over again that we do this for a living. However, this is strictly educational. We're not trying to sell you anything or anybody. This is just strictly educational. The eval form and the sign-in sheet, however, I do need filled out and sent back to me, Sheila@Haiman+Hogue.com, and that way I can send you your certificate.
Great.
Very simple.
In addition to that, there'll be a Google survey. It should pop up as you close out of your Zoom today, but I know some of the companies have pop-up blockers. And so if it doesn't pop up, you'll also receive the link to that Google survey. And that's just for our records. We need to do that for the funding sources in order to report back on objectives that we've set forth when we applied for the funding. Now for next month, there's not going to be a next slide because we were working this out. But for next month, we are going to be doing blended family nightmares is what in general is what we're going to talk about. And that will be on the 12th, the morning of the 12th of July, and will be from 10 to 11:30. And I will have that set up in that flyer in tomorrow's follow-up email from today. Sheila and Rex, thank you so very, very much. Absolutely.
Thank you.
Great information. Thank you all for joining us, and y'all have a wonderful day.
Okay, thank you.